We cannot have a situation where you direct President of India. And on what basis? Article 142. Article 142 has become a nuclear missile against democratic forces. Available to Judiciary 24/7. My worries were at a very highest level. I never thought in my life I'll have the occasion to see it. President of India is a very elevated position. President takes oath to preserve, protect and defend the Constitution. This oath is taken only by President and her appointees, the governors. Everyone, the Prime Minister, the Vice President, the ministers, the parliamentarians, the judges, they take oath to abide by the Constitution. But to defend the Constitution, to preserve the Constitution, to protect the Constitution, that is the oath of the President of India. The Supreme Commander of the Armed Forces. Boys and girls, if you look at the Indian Constitution, when Parliament is defined, according to you, Parliament is Lok Sabha, Rajya Sabha. No. Parliament, the first part is the President. Second and third are Lok Sabha and Rajya Sabha. There is a directive to the President by a recent judgment. Where are we heading? What is happening in the country? We have to be extremely sensitive. It is not a question of someone filing a review or not. We never bargained for democracy for this day. President being called upon to decide in a time-bound manner, and if not, becomes law. So we have judges who will legislate, who will perform executive functions, who will act as super parliament, and absolutely have no accountability because law of the land does not apply to them. Let me tell you, boys and girls, every parliamentarian, and why parliamentarian? Every candidate in any election to assembly or parliament is required to declare assets. Judges don't do it. Some do, some don't. Time has come. We cannot have a situation where you direct President of India. And on what basis? The only right you have under the Constitution is to interpret the Constitution under Article 145(3). There it has to be 5 judges or more. Boys and girls, when Article 145(3) was there, the number of judges in the Supreme Court was 8. 5 out of 8. Now 5 out of 30 and odd. But forget about it. The judges who issued a mandamus virtually to the President and presented a scenario, it will be law of the land. have forgotten the power of the Constitution. How can that combination of judges deal with something under Article 145(3) is preserved? It was then for 5 out of 8. We need to make amends in that also now. 5 out of 8 would mean interpretation will be by majority. Or 5 constitutes more than majority in 8. But leave that aside. Article 142. Article 142 has become a nuclear missile against democratic forces. Available to judiciary 24/7. Constitution framers were very wise people. People who deeply believed in national welfare. They debated for 18 sessions for over little less than 3 years. There was no confrontation. There was no disturbance, no disruption. There was dialogue, debate, discussion, and deliberation. Very contentious issues. But they framed one rule. The judges will be appointed under Article 124. And a consultation word was used. Boys and girls, you know the word consultation? Lexicon defines it. Consultation is not concurrence. Consultation is consultation. Article 124 was very specific. And with respect to Article 124, we have a very important discourse by Dr. B.R. Ambedkar. And B.R. Ambedkar, who did a great job in giving us this constitution. I'm quoting him. This was with regard to the question of the concurrence of Chief Justice. And Dr. B.R. Ambedkar says, I quote, boys and girls, for your benefit. I quote, I think to allow the Chief Justice practically a veto upon the appointment of a judge is really to transfer the authority to the Chief Justice, which we are not prepared to vest in the President or the government of the day. And Dr. B.R. Ambedkar goes on to say, I quote, I therefore think that is also a dangerous proposition. But in the second judge's case, in 1993, the court interpreted consultation will be read as concurrence. Can it be done? The two words, boys and girls, are different. But the bench did not notice that Indian Constitution uses these words, consultation and concurrence, in the same article, Article 370. With respect to the then state of Jammu and Kashmir. Article 370 has both expressions in the same sub-articles. How can these two words used differently by the Constituent Assembly members in the Constitution can be read differently? It was done. Now, the situation is engaging attention of everyone. And it is our obligation as citizens of this country to think about how things have to evolve. Let me take incidents that are most recent. They are dominating our minds. An event happened on the night of 14th and 15th of March in New Delhi at the residence of a judge. For 7 days, no one knew about it. We have to ask questions to ourselves. Is the delay explainable? Condonable? Does it not raise certain fundamental questions? In any ordinary situation, and ordinary situations define rule of law, things would have been different. It was only on 21st March, disclosure by a newspaper, that people of the country were shocked as never before. They were in some kind of limbo, deeply concerned and worried at this explosive, alarming expose. Thereafter, fortunately, in public domain, we had input from authoritative source, the Supreme Court of India. And the input indicated culpability. Input did not lead to doubt that something was amiss, something required to be investigated. Now the nation waits with bated breath. The nation is restive because one of our institutions, to which people have looked up always with highest respect and deference, was put in the dock. It is now over a month. Even if it is kind of wounds, even if there are skeletons in the cupboard, time to blow up the can, time for its lid to go out, and time for the cupboard to collapse. Let the worms and skeletons be in public domain so that cleansing takes place.